I'm Poppy Kite and I'm a solicitor in the contentious probate team at DMH Dallard. I'm going to explain what happens when someone dies without leaving a will, something that is called dying intestate, and how their estate is distributed under the rules of intestacy. When a person dies intestate, it means there is no will to direct how their assets, such as property, money, and possessions, should be distributed. If this is the case, the estate is divided according to strict legal rules. The Intestacy Rules are somewhat archaic and impose a structure that reflects a traditional view of family, giving legal priority to marriage. In modern day society, less and less people are getting married, and cohabitation is increasingly common. As a result, more individuals risk having their estate distributed under the Intestacy Rules in a way that may not align with their personal wishes. The rules are set out in the Administration of Estates Act 1925, and they prioritise close blood relatives and legally recognised relationships. Generally, the Intestacy Rules establish a hierarchy of individuals entitled to inherit an estate, listed in the following order of priority: spouse or civil partner, children, whether biological or adopted, parents, full blood siblings, half-blood siblings, grandparents, full blood uncles and aunts, half-blood uncle and aunts, and if there are no surviving relatives who can inherit under the rules of intestacy, the estate ultimately passes to the Crown, a process known as bona fidencia. In today's society, cohabiting couples, often incorrectly referred to as common law spouses, represent one of the most common types of family relationships. Over half of all children are now born to unmarried parents. However, intestacy rules do not recognise cohabitees regardless of the length or seriousness of the relationship. Similarly, stepchildren have no entitlement under the intestacy rules unless they have been formally adopted. In contrast, an estranged spouse may be legally entitled to inherit the majority or even the entirety of an estate if their spouse dies without a valid will. This is often entirely at odds with what the deceased would have actually wanted. When an estate is distributed in a way that the deceased likely did not intend, there is an increased risk of disputes. Disappointed or excluded individuals may bring a claim for financial provision from the estate under the Inheritance Provision for Family and Dependents Act 1975. These claims may delay the administration of the estate, result in substantial legal costs, and cause emotional distress, often damaging relationships among family and friends. The only way to ensure your estate is distributed according to your wishes is to make a valid will. If you make a will but it is found to be invalid after your death, your estate will either pass according to an earlier valid will, or if none exists, under the Intestacy Rules. If you believe that you may have a claim against someone's estate, then please contact our experienced contentious probate solicitors.